Next up, we have Todd Strong. Todd is Todd's most well-known case handled from trial to the Supreme Court is Wills versus Foster, holding the collateral source rule permits recovery of all reasonable medical expenses, not just amounts paid by a collateral source such as Medicare or group insurance. And a fun fact about Todd is he was present at the trial of Gear versus Industrial Commission, known as the Gear objection. And he's going to talk to us about post-settlement and award issues. Thank you.
Thank you. I'm Todd Strong. I practice mainly in the central Illinois area, downstate. I didn't try the Gear case, so don't point the finger at me. I just happened to be present at the time. So my talk this morning is about post-settlement, post-award issues. Your case is closed. You've dispersed your settlement funds. You've sent your file to the filing cabinet. You've told your file clerk to send that away to the warehouse. I don't ever want to see it again. I hope never to have a phone call from that client. And 1 year later, you hear your receptionist ring through this client and you start having post-traumatic stress disorder syndrome. But you take the phone call. What is the phone call about? It's important to take that phone call. And before we get to that phone call, I kind of want to review some good practice pointers for closing your file. I think it's good practice. We all use disbursement statements for our clients. I put language in my disbursement statement that this concludes the attorney-client relationship. I think that's good practice. I think we should all do that. You get now fast forward a year after your settlement disbursement, after your award, your disbursement of your award, you get that phone call. What is it about? Well, when I got the phone call from Howard about what topic I wanted, he let me pick the topic, and I just happened to be finishing this case that called the Dwayne Stutler case that I worked on for probably 6 or 7 years after the settlement. And it was a very frustrating process. And this was a very large case. It was a settlement of a perm total case that called for payment of all the medical bills. And there ended up being over $300,000 in unpaid medical expenses. I get the call from the client. The client says, "Hey, you didn't finish my case. I'm turned over to the collection bureau. I just got sued." And he's thinking I'm a lousy lawyer. Well, he sends me the bill, and sure enough, it should have been paid. I sent it to the carrier. The carrier blows us off. So what do? We file a 19G action in circuit court. And that's when you go through my file materials is the start of the story. I filed then a penalty petition in front of the commission on the Commission on Review. When I first started practicing, I would file these petitions in front of some of the older commissioners when I started in the early 90s. You could go in front of the commissioner one time and say, "Look, here's the contract that called for payment of the bills. These people didn't pay the bills," and the commissioner would yell at the defense attorney to get the bill paid. That doesn't happen anymore. It doesn't happen at all. There's an extreme reluctance with the commission to enforce and award penalties. So I appeared on review 8 times. During those 8 times, I kept hearing, "The bills are paid, the bills are paid." They weren't paid. We end up having a hearing. So I'm filing in circuit court. The circuit court says, "Go back to the commission, find out what's related, what should have been paid, come back to me and I'll enter your judgment." So in this case, I kind of want to go over some practice pointers for the filing of a 19G. If nobody's ever filed a 19G, or if you haven't filed a 19G, I put a copy of my petition as an exemplar or a sample. I think what I want to call to everybody's attention is don't be afraid to name the insurance carrier as an indispensable and necessary party. That really gets their attention. When you get their attention, then you get calls from coverage lawyers. They're trying to sort it out. What is this? We don't see these on a regular basis. So name the insurance carrier. The second practice pointer is make sure you name the correct corporate identity of the employer that you're suing. Think of this as a civil lawsuit. You're converting the commission award or the commission contract to a judgment. It becomes a collection action. So you have to dot your I's and cross your T's for circuit court purposes to make sure you've named the party correctly and that you've served them correctly. Educate your circuit court judge. Educate him or her as to the law. Spoon feed it to him. Most of your circuit court judges, particularly downstate judges anyway, they don't see this very often. They say, this is the commission, we don't want anything to do with it, you should be at the commission. The commission says, we don't have the power to enforce settlement contracts, we don't have equitable powers to enforce decisions. So you get ping pong back and forth. So educate your judges, educate your commissioner that you're in front of on review, spoon feed them the law. What do you do in front of the commission? What did I do in this case? I appeared 8 times with the respondent's counsel. His excuse for non-payment changed each and every time. Your Honor, these are paid. We've given counsel a payment ledger. And I'm like, well, yeah, Your Honor, I've looked at the payment ledger. It doesn't call for, or it doesn't show the $300,000 of bills. Your Honor, and I like this one. Your Honor, we've paid over $1 million in this bills. We've paid enough in this case. I'm like, what? What's supposed to happen with this $300,000? So build your record. So in this particular case, I filed penalty petition. You start off with a generic, easy penalty petition, but then amend it when you go back to successive hearings and make a record, because we know that they don't make records on your pretrials in front of your commissioner, and the commissioner says, or the respondent's attorney says, we're looking into this, we're having our fee schedule department. Have you ever spoken to anybody at a fee schedule department? I haven't. The adjuster usually says, oh, we've sent it off. We've sent it off for review. We've sent it off for a fee schedule analysis. There is no fee schedule analysis, or when you get them, it's a spreadsheet that it doesn't show anything to it. Build your record. The commission, in this case, finally allowed me to go to hearing after 8 separate requests. The commission granted continuance after continuance after continuance until I finally filed a penalty petition chronicling each and every time that I appeared at the Peoria review call. When I did that, we finally get to hearing. I bring in the doctor. The doctor says, I've checked with my billing department, I own this practice, here are all these medical bills that are unpaid. What are these bills that are unpaid? Because this attorney tells me that they're paid. These bills were things like implant charges. Well, doctor, you did a 3-level lumbar fusion on this gentleman, and you put a dorsal column stimulator. Can you do those surgeries without implants? No. Do you need an implant? Yes. I mean, these are really stupid things. Here's the receipt that we gave the insurance company for the implant. Here's our 25% markup under the fee schedule. Well, our fee schedule department, denied this bill. We're not going to pay it. It's not related. Here's the IME doctor that said this surgery is all related. Here's the treating doctor. Nobody disagrees except for the fee schedule department. So, bottom line, this case did go to arbitration, or go to hearing on review. We were awarded about $100,000 in attorney's fees and penalties, but I learned a lesson. Phil, when he came up, talked and analyzed about things that he'd made a mistake. In going back and reviewing this file, I made mistakes. And I want to point out some of those mistakes because some of the bills that were pre-approved and pre-authorized, the commission retroactively found that those bills were not payable per the terms of the contract. We're talking about $90,000 for a left shoulder surgery. On this client, he had injuries to both shoulders, both hands, both arms, his back, his leg. He was crushed when a tractor fell over on him. He had multiple body parts. You couldn't fit that number of body parts on the application on the form given by the commission. We put several in there, but for the hip and one of the shoulders, we put MAW, man as a whole, thinking that that was going to be good enough as sort of a catch-all. The commission denied that. So a good pleading part when you're doing your contract for multiple body parts, make sure if they're going to pay all the bills or pay all related bills, have your contract terms be more specific. Pay related bills to the left shoulder, to the right shoulder, to the left hand, to the right arm, to the left hip, to the low back. Be specific in your pleadings. I learned a lesson on that. Now, fortunately, even after this petition, or the commission granted all these penalties, I went back to the circuit court. We were able to get it resolved and get all of the bills paid when the circuit court took a look at it. So that's a lesson. I've given a copy of the case. I've given some sample petitions. The other thing, so that you can ask for when it comes to enforcement of medical bills, attorney's fees pursuant to Section 16, 50% penalties for 19K, but don't forget your pleadings for interest on the bills. And I've enclosed a sample petition for assessment of interest that I put together. And I included, and I attached to that pleading a memorandum from the Department of Insurance that came out when Quinn put the fee schedule in and back in the older amendments. To my knowledge, this memorandum of the Department of Insurance is a correct statement of law, and it's still applicable, and it's never been changed. So this is the policy of the state of Illinois, is that insurance carriers for undisputed bills should be assessed at 1% interest per month. I was awarded that in this case. What's important is, from a practice standpoint, talk to your medical providers and ask if your medical providers have billed the insurance. Insurance carriers are actively paying interest on medical bills that they let sit for a year or more than the 60 days allotted under the statute. However, in order for the provider to get paid the interest, they have to bill the interest. The insurance company will never pay anything unless they get a bill. If they get a bill, it's payable per the fee schedule. It's right in the statute. And what the petition for assessment of interest, to me, brings this to everybody's attention. And it gives you another leverage or another document to help get your bills paid, your client's bills paid. And ultimately, at the end of the day, that's what we're after. Does anybody have any questions on that? So the next part of my talk for post-settlement that I want to get into is what I feel a little bit of a lost art. And why I say it's a lost art, I practice mainly downstate in central Illinois, and there's only about 2 petitioners lawyers, myself, on the Williams and Swee office, that routinely file 8A petitions for lifetime medical benefits and 19H petitions. I don't practice very much here in Cook County, so I'm not sure if that's a regular practice or not. But it's vital, I think, and it helps your underlying practice. If insurance carriers and defense attorneys know that you know how to enforce a client's lifetime medical benefits under Section 8A, or his 19H rights for increased disability at a later point in time, you're going to be in a better position to negotiate a settlement. What's the first thing that they want when you settle a case? They want you to waive 8A, they want you to waive 19H. Well, the arbitrator pre-tried this case at 20%. I'm not going to pay any more than 20%. Well, that's what the arbitrator said he was going to award. So what compensation, what consideration are you going to give the petitioner for waiver of a right to lifetime medical? What situations are important to consider that medically and factually? The biggest one that I see come up a lot is adjacent level wear and tear for fusions. Doctors are really aggressively looking at this. There's a lot more medical studies and there's a lot more evidence medically that the level above or the level below is now at risk because you've fused two vertebral bodies together. That's important. So if you have a client, you're settling for 25% man as a whole because he went back to full duty work on a lumbar fusion, consider that client 1 or 2 years from now may call you and say, hey, my back started hurting, I went back to the doctor, I got to have another surgery, and they got to fuse the level above or below. If that client waived the medical, you ask them, did you get hurt again? No, you didn't get hurt again. Well, there's nothing I can do. You settled your case. So think about the value, the extra value that 8A brings to the table when you're negotiating. If the respondent's attorneys know that you know how to file these, you know how to pursue them, and you're not afraid to pursue them, that's going to add value to your other cases that you're handling. Same goes for 19H. Well, before I get there, some other cases other than other medical conditions that lifetime medical is important is prescriptive medication. If a client has to be on prescriptive medication is extraordinarily expensive. There's value to that. You can ask the doctor to provide you a letter with prospective medical costs or prospective future medical treatment. Dorsal column stimulators. If you have clients that have these, they usually have to be replaced after 5 years. The leads break, the leads got to be replaced, requiring another surgery. The battery's got to be replaced. They've got to go in to see Medtronic once a year or once every other year. There's lots of costs to that carriers want the petitioners to pawn off on the taxpayer through Medicare or Medicaid or collateral coverage through group health. Add that to your case. That adds value, brings value to the table. It's part of your negotiation process, even on petitioners, if there's any instance where there could be or might be future medical treatment. Another one is joint replacement. When I first started practicing in the early 90s, the knee replacements, I think, were lasting 5 years at that time. Now, you don't see these as much because the joint replacements, usually you can't outlive the joint, the titanium material that they're using. (19H) is my last topic. This is really a lost art. I was researching what I thought was the case law on this. There's very, very little case law out there. That means we as a body are not filing these petitions and we're not enforcing our clients' 19H rights post-settlement. When you settle, or when you disperse an award, not usually a settlement, when you disperse an award, educate your client. When you send them that closing letter, your case is now closed, here's your disbursement. By the way, if you need future medical, please give me a call. If you have, if your condition worsens, please give me a call. And then that way you can discuss it with the client to see if you have a viable 19H action. Most carriers, when you file the 19H or 8A, will typically say, our file's closed, the respondent's attorney won't return your phone call. So you've got to start that case all over again. What do? Just like for a 19G action or a post-settlement 19K, open it up and treat it as a new legal matter. Have your client sign a new fee agreement. Have your client sign a new HIPAA. Open up a new file because it's a new, and treat it as though it's a new legal matter, because it is. It's a separate issue. It's a separate part of the case. A lot of times we've treated these, a lot of practitioners in the past have blown these off for reasons that they just don't want to deal with it because, well, I've closed the file, I've collected a fee, I'm never going to get paid on this. Don't treat it like that. Treat it that the case has value, because it does. And be realistic. Now, we do have some clients that will call up and say, I have one $6 prescription. Well, obviously, you've got to weigh judicial economy, weigh the court's time, weigh your own time, and that sort of thing, and use your own best judgment. But 19H is viable in the terms of the statute. I've provided a copy of the statute for injuries or disability. It's important to distinguish disability, that the disability has reoccurred, that the disability has increased. Conversely, this remedy is also available to respondents. It's very rarely used by respondents, but I have had a couple cases over the years where somebody's collecting a perm total and the carrier wants to come in and try to say that the person is now capable of work and they want to stop the perm total benefits. Or you see it come up in a lot of times in a wage differential. Well, they'll try to say, well, the guy's now making 3 times what he was before. Those are very difficult cases for respondents to make, but know that 19H is available to both sides of the bar. In our case, we want to know, has the disability increased? The most common factual scenario I have found is a wage differential award where you're granted a wage differential award and then the petitioner may lose his job. But the most common is where the employer says, well, I'm not going to pay him on a loss of occupation. We're going to accommodate the permanent work restriction. And he has let's say, an unoperated herniated disc. He's got a 25-pound lifting restriction. The employer says, we're going to accommodate that. And you arbitrate the case, you get the award, or conversely, you settle the case and leave medical in 19H open on an award situation. And then the employer says, after a year, well, you're fired. We're going to let you go. So that brings 19H back into play because the employer is no longer accommodating that restriction. So how has that impacted the level of disability that the petitioner had upon the entry of the award? So don't be afraid to file these petitions. You're going to have a hearing once every 3 months or 3 to 4 months on review. To your assigned commissioner. You're going to be dealing with the commissioner at the review call rather than the arbitrator at the arbitration call. Does anybody have any other questions? Yep.
We've had a situation where the respondent or the respondent's case manager convinces the hospital authorities to bill most, if not all, of the medical to the employer's group insurance. And then subsequently you get the group insurance and the bills, and it shows that the group insurance has paid some boxcar figure for medical care, which they really were not responsible for. How do you handle that situation?
The first thing I look at is which group health insurance carrier of my client. So was it the employer's group health insurance carrier where the employer would arguably have an 8J credit situation? Or was the nurse case manager being slick and saying, well, your wife works for the city, why don't you just bill hers? You're listed on her insurance, use that group insurance. There's no 8J credit then. And so I would treat that situation as the bill is unpaid by the respondent, collect the bill, send it to the employer and say you need to pay full fee schedule. So if they send a check to the hospital then therefore theoretically under subrogation is to send the claim back. If the case is truly accepted, then I would contact the hospital and say this is an accepted, approved case, this should be billed to the work comp, and I give the medical provider the work comp adjuster, claim number, contact information, and say you may want to consider billing it this way rather than through group. If the nurse case manager becomes too, and we've all dealt with nurse case managers that get too invasive into your case, too pushy, and start intervening in things that they really shouldn't be dealing with. For example, a nurse case manager should not be making billing decisions. That's not within her scope of expertise. if I get a sense that a nurse case manager is being too invasive, I cut that access off to that nurse case manager. I hope that answers your question.
In my situation, the union, this petitioner was a member, actually paid these bills. So I would assume that they would want to be involved in some fashion to try to get back their money.
Depending on which union, definitely. So a union theoretically may or may not, there may or may not be a 8J credit issue. But if the union is seeking subrogation, I get a copy of the full itemized medical bill and all of the UB40s, and I treat it as an unpaid bill, and I submit it to the work comp carrier and or the respondent and say, this bill needs to be paid. So that, I would treat it as an unpaid bill, even though it's paid. Now, you're going to hear blowback from the employer or the employer's insurance company saying, well, they accepted a negotiated rate. So then the issue is what involvement or to what degree is the union's health and welfare benefits fund involved? You know, are they receiving the premium substantially from the employer, or is the employee paying the bulk of the premium? And you go through an 8J credit analysis. Any other questions?
Todd, you had mentioned using 19H in an economic layout where someone's getting like an 81. Have you had success bringing that type of argument to a commissioner?
I've only had success in the sense that it helped facilitate a settlement. So I haven't tried a case on that particular issue. Ian.
Todd, this is being recorded. Can you say the question and then answer it? I apologize.
Okay, I'm sorry. I think Ian wanted to know whether or not if I had brought a case before the commission where a petitioner was being paid out an 8D1 award under wage differential, lost the job, and then we filed a 19H, and we're seeking additional disability compensation or 19H. Did I state your question correctly? Okay. So in that situation, I would certainly file the petition and make the argument. It is a tougher argument. I'm not aware of any case law that has went all the way up to the appellate court, but I've had that situation 2 or 3 or 4 times where typically, and when you get into these review situations, for the most part, if we carve out the settlement contract enforcement issue, where you're doing a post-settlement 19K petition, and you're looking specifically at a case that you've arbitrated where there's been an award, where a condition is found to be causally connected, there may or may not be some level of disability, and then there's an increase. Insurance carriers, in my experience, do not like dealing with cases on review. And when you file these, lay out your evidence right away, get copies. I typically try to get copies of the medical records before I file the petition, just to make sure I've got a good factual basis. And then I serve them immediately with my evidence and the petition right up front. And they'll typically, even if there was a prior respondent's counsel, that respondent's counsel's file is closed. You're now dealing with the adjuster, and it gives you a crack at trying to get a closed-in settlement contract with the adjuster. And I think it's a good methodology. Don't file those petitions until you get your ducks in a row from evidence. You know, ask your client, well, if you need future medical, do you have a letter from your doctor? Do you have a prescription slip from your doctor? Or get copies of those records. Do you have increased disability? Do you have adjacent level wear and tear? Do your due diligence. Get your evidence before you file your petition and go to the commission. You're gonna be in a much better standing before that commissioner if you've got everything laid out in your petition. Any other questions? Thank you very much. Got you to break.